Good afternoon. We are going to call to order the March 31st, 25 meeting of the Charter Review Committee and move to Madam Clerk for the roll call.
Okay, Kevin Cox,
Here.
Kurt Geis,
Here.
Andrea Honeycutt,
Here.
Sal Murillo,
Here.
Yumiko Motley. We are all here.
Agenda is to approve the minutes of the meeting from the March 3rd meeting. Is there a motion?
I'll make a motion.
Second.
Motion first and second. All in favor?
Aye.
Opposed? Motion carries. Okay, so we're going to move into the initial review of the select charter provisions and the charter language revisions provided to us by the town attorney by way of the Post Law Firm.
Hello, everyone. As you can see, our firm has provided a memorandum with some just items we had pulled out that we thought might benefit from a cleanup, either a cleanup to clarify what the meaning is or to get rid of some requirements that for various reasons might be particularly onerous or just not feasible for the town to accomplish in the time period specified. So I'm not going to go through each one of these tediously. I know that all of you have had some time with the agenda packet, and so I thought that if anyone had particular items that they wanted to pull out for discussion, we could do that.
So for number one, the issue of what does it mean to have permanent residence in a town comes into play. Do we want to address it here? Do we want to say that that's not important? Opening that up.
Yeah, that would be an item for discussion.
Most of the charters in other towns don't do any better job than we do of defining that. The only one that was a little bit different was Belle Isle. And they basically they said a resident shall be considered a bona fide residence under this section if it is subject to a valid homestead exemption in the records of Orange County Property Appraiser. That's basically what I was really not much different. Is anybody else have any?
I think my inquiry in response to your question would be, is there a statutory definition?
For charter purposes, I don't believe so. Now, there may be, some definition tucked away in some statute for residency as used in some other context. But if I were going to look at what does residency mean in a charter context, I would be looking at case law, most likely.
Yeah, and reading through it, there was another one too where I think the word qualified was used in a different section. And same thing, it implies that we understand what qualified is, but I didn't see any reference. Same would be for resident, for the avoidance of doubt, if we could just spell that out, what I think it is, whether it's case or statute or something, just to put it to bed. That's my opinion. We can define it.
Which charter section are you referring to? Are you
For which part?
the word qualified?
I believe that would be section 2.4, qualifications it reads, only qualified electors of the town who have resided continuously in the town for at least 1 year preceding the qualifying date shall be eligible to hold the commission. And so I think based on the prior inquiry, the question would be what qualifies the preceding year. And obviously that was kind of defined as homestead for 1 year.
Okay. That is, I will take a note of that one and look into how we might define qualified. Is that all right?
Yeah, just for the avoidance of doubt, right? Unless somebody has a strong feeling, just say, hey, it's as referenced here or there.
I think more specifically, the continuous, resided continuously would be the more specific inquiry as to what defines continuous residency. Obviously, we say, you know, homestead exemption, maybe leaning to some case law or something that clarify for purposes of the committee as what that year is comprised.
I guess the one issue that came up when I was talking with someone else was the issue of a snowbird. Is what if someone wants to live in Oakland, you know, during the nice part of the year? That's something. Anyway, I mean, it's one of those things that doesn't happen, but it's just an opportunity while we're talking. You need to be a resident of the town. It'd be something that could be delineated a little better.
So under section 2.5 subsection B2 of the charter, that is the provision governing forfeiture by absence. And that section provides that if a commission member is physically absent without good cause from any 4 regular meetings of the commission during any calendar year, or is physically absent without good cause from any 3 consecutive regular meetings of the commission, that constitutes forfeiture by absence. So to me, this would narrow down on is being a snowbird good cause for missing a whole bunch of commission meetings. I tend to say no, because that's, you know, it's not an unforeseeable illness or accident or something like that, which I would generally say that that is what good cause would be. So
I can sort of see, I mean, let's say nothing real drastic on in town, and the commission members all get along fine. The mayor gets along fine with them. And then someone says, you know, I think I'm going to go up north for a few months. I'll be back for the meetings or something. And I could see that being, you know, just because, hey, you're my, you know, not because, well, that really doesn't sound like a good reason for you seeing me.
So I have a question. Is the concern about like legal residency or participation in the community? Right, one kind of implies, so if I'm a legal resident, but I never leave my house, I never participate, I never come to the meetings, I never go to any of the events, am I qualified, right? Like, I'm asking, I don't know, like, is it just a legal definition of I'm a resident, or do I have to be a participant? I guess I'm trying to figure out which one.
in my legal opinion, there would not be a way. So the word residency does not involve community involvement. That would be a different requirement. If that answers your question.
Yeah, I can't presume that we would even attempt to define what participating member of the community is, right? So I'm trying to figure out what can we define, what should be defined. And does that satisfy, I guess, the concern?
So if it helps at all, I do believe Akoya addressed this in their last election. I think I was just talking to their city clerk and she was going to send me their ballot language and a little bit of wording, because I think they may have addressed this specific issue a little further. I'll try to get that for the next meeting.
Just as a matter of qualification is the residency. So I think the homestead is the check and balance on residency, absent someone providing information that they're claiming homestead in another.
What if they're renting?
That makes sense. If, so let's say, someone is a snowbird, but they're claiming homestead in another state. And here, that would kind of like, in a lay term, be a conflict of precedent. I repeat. So it may not be homestead, but they could be a renter that's been registered to vote in the town of Oakland for a period of a year.
Or provide a lease. If they're renters, then they should be able to provide a lease.
Yeah, so Kurt,
For that.
that's a really good question because currently under your charter, they would be allowed to run. But if you did a homestead without having an exception for renters, then that would be an issue, right?
I think that's a very good point. Particularly because I would want to look more into if there could be some sort of kind of inherent accidental discrimination against renters. And we wouldn't want to be doing that. So thank you for that comment.
Just from a plan. Did apply for a vacant position. One of the requirements was that I was a registered voter. And so that may be our look into the dynamics of a renter, but a registered voter in the town of Oakland, the requisite period. And that could possibly alternate and or provision.
Do we know what the requirements are to be a registered voter in Oakland?
I couldn't say, so I apologize.
Doesn't it have to match your address on your driver's license?
I would imagine that's, personally, when I register to vote, I do it with, you can do it at the DMV or get that little card in the mail.
I'm personally fine with the word have it as their permanent residence. I don't know how you change. You start getting into weeds and go down paths that could discriminate against people who are residents that actually rent, that go away for the summers. And if they come back to meetings, that's fine. They're engaged in the community. They live here. This is where they pay their taxes. This is where they register to vote. If you start trying to define it much more than that, I think you're going to ask for problems.
I can say that the term residency generally wouldn't include things like, yeah, I own a second home there and I really don't spend a lot of time there and it's not where I intend to grow old and die. Now, that would be someone that I would say is not a resident of Oakland. So the word residency does mean a lot, even though it is undefined. If in case that kind of informs anyone's decision on this matter.
Police, maybe that's number 2 is that charter amendments, next page.
Okay, so this may be what they were referring to, which it's question number 2, amendment of the Kauai City Charter to authorize city commission to judge candidate qualifications. Section C10 of the City of Ocoee's charter shall be amended to provide that the city commission has authority to judge the qualifications and eligibility of candidates for the commission, establish procedural rules for C10, including ensuring that notice and due process is given to affected persons and provide for review of such decisions by a court of competent jurisdiction. So I'm sure that's the one she was referring to.
So I was trying to understand what you were saying there. Does that mean the commission votes on who gets to run against them? The commission gets to vote who's qualified to run against them?
I think it sounds like if there's a question as to qualifications, the city commission and Ocoee makes that final decision.
I do, however, believe that candidacy, you may be signing an attestation clause that the facts that you're presenting that prove your residency are accurate. And that's your statement of truth until proven otherwise. So if that were contested, essentially, then it would put you in a disqualification.
Yeah, so we don't ask for proof of residency. All we require, they have to certify that they meet all the qualifications, and it's very specific as to what those are according to the charter.
Again, absent someone contesting a person's residency classification, they have signed a declaration of candidacy, and once they affix their signature, that to the best of my knowledge, truth and belief, or whatever the course may be, they're saying, I'm a resident, or if someone were to challenge it, that finding be true, then it would lean to disqualification. But for purposes of actual residency, I think the homestead, whatever's listed there, at least it's the further.
On our, sorry, current qualifications? Is that what you're asking?
No, I think you were leaning to the actual, maybe declaration of candidacy, the things that it requires a residency to like check and.
Yeah, it's just to basically say they're a resident of the town of Oakland, a registered voter. Those are basically our requirements. And so I just have them sign and certify that that's the case. So they're self-declaring. Just to be clear, that the clerks are not responsible for verifying the information. They're just basically doing the administration part. I learned that one early on. So I'm looking real quick just to let you know for voter registration, the ID requirements are a current and valid Florida driver's license or Florida ID card number or last 4 digits of your social security number. It's really all they require.
Stephanie, I think that one of their main purposes was to try to think that was
If I may, in my view, that charter provision would be more likely to result in litigation. Because if the town commission were to make a decision that someone did not agree with and did not like, that would be the cause for.
I mean, the first suit I would have would be is why are you qualified to judge me? I mean, they're not all attorneys. They're just members of the community who were voted into office. So I would think that would create more problems.
I'm not for that.
I did have one, I guess, question slash clarification on number 4, section 3.4.
Okay, so before we move on
Yeah.
to another
Another-
section,
Oh, okay.
I just want to make a point of clarification that obviously, um, indicated clean the case law regarding that quote residency definition, and maybe we can form that research and come back with a more clarified, position on case law lens too, with regards to that. I'm okay with the provision as it reads, but there was a little consternation, and so if that research could be provided more.
I will certainly, as a sort of preliminary matter, I can say that the case law revolves very closely around the person's intent, where they intend to remain, where they intend to live. But I will bring you some more concrete definitions out of the case.
Awesome.
Yeah, awesome. My question pertained to number 4, section 3.4, acting town manager. I don't know. Anyone had something before that? Want to go in order, or we could just jump to that? All right, so my question was two-part. So the language all makes sense to me. Two things popped out. One was the word qualified, right? So it reads, the town manager shall designate, subject to the approval of the commission, a qualified town employee, et cetera, right? So what jumped to me was what's qualified, right? What defines that? And then at the bottom, at the last line, it reads, as acting town manager until the town manager shall return or his or her disability shall cease. And I was wondering, is duration a concern, right? I mean, is the acting town manager put in place until the end of the term? Is it expected to be 90 days, 60 days? Like what? I don't know. So those were the two things. What's qualified and what's the duration of an appointed person, right? So I'll just.
So as to the duration, I understand your question. I might offer some practical insight about how things might turn out if we were to add a time limit. So this provision is meant really to govern in the instance that the town manager is seriously injured or falls ill, simply cannot perform her duties for one reason or another. If we were to say, hey, maximum time period for an acting town manager is 60 days, then in the event that the disability or other reason for the town manager's absence goes longer than that, we might be stuck in a position of having to then have the town manager designate someone who could be less qualified to serve in that person's stead. So I think not putting in a time limit would potentially put the town in the best position of having the most qualified staff member take on those duties. And qualified in this instance, I mean, it really means, does the town manager and do the members of the commission think that the person is qualified? It's not a very meaningful word when used in this instance, if that makes sense. We pulled this provision. This is a very standard charter provision. The reason why we added this language is because it appears that there was just some sort of clerical error that happened the last go round when all this was adopted, and some of the language was simply cut out. So it kind of started mid-sentence and we're missing some words. So this is just the standard kind of what you see in a lot of jurisdictions.
That based on a quote qualification standpoint, there is a provision that the commission can revoke that designation and appoint another employee. To your qualification point, I think that the section 3.4 does provide from a qualification.
There are certainly guardrails on this. You know, if an if an acting town manager is appointed and then that person starts doing a whole bunch of stuff that nobody's okay with, the town commission certainly can take care of that.
Okay, yeah. Is that, so apologies, where is that?
So section 4 of our, well, actual section 3.4, acting town manager. If you look to the,
It's the second part of the recommended.
so if you're actually in the charter, that's in the recommendation plan from the, I would go to the Vo's memo.
Okay, it's in the proposed one. Okay.
It's not even a deletion or addition. It's already in the text.
May revoke the appointee. Okay, you got it. Thank you.
So I hate to say this, but I'm a orderly person, so I know we jumped to section 4, but I don't want to not address the provisions that preceded it, just to make sure that we touch them. And so we did do the forfeiture by disqualification. Were there any questions or inquiries about that proposed language? I think I did have a cleanup item, and it could just be a grammatical thing for me. The underlined language said the commission member, and I just would put the word if before the commission member. So forfeiture by disqualification, commission member shall forfeit his or her office if at any time during his or her term. Oh, okay. The if is in a.
That work for you? Okay. I think there's many ways to skin the cat on that one, so.
Additional commentary or the by definition.
That was the one that we were going to wait on.
So the next section in the memorandum would be the filling of vacancies. So I have several questions as it relates to the filling of vacancies, and not against the language that's being proposed, because I do agree with a longer time frame to fill the vacancies. However, I'm leaning to the provision that the governor would appoint in 30 days. And I'm looking for some guidance as to whether there is any statutory guideline about when the governor would come in to appoint. And so I guess my question is there a conflict of law, or does the charter control as to when they would allow the governor to make?
I apologize. I'm a little bit confused about the question. Are you talking about how long of a time period needs to elapse before it then becomes incumbent upon the governor? The charter controls in that instance. And once that, be it 30 days, 60 days, or 90 days is reached and no appointment is made, it is then out of the town commission's hands. And I can just say as a practical matter, based on what I've observed, I've seen seats go vacant for long periods of time because the governor it's not at the top of his list to make these appointments sometimes.
So then I think the next question would be, what would be the pleasure of this committee as to the time frame for filling that vacancy? Obviously, the charter currently reads 30. An example of extensions would be 60 or 90 days. How comfortable would we be on what that time frame for filling a vacancy would be before we allow gubernatorial intervention? So it's 30 now, but could we conceivably keep it there, or should we do it longer? Because I think 30 is very restrictive. If we're not able to, we have 2 meetings a month. So that means we have to post, we have to give time for the applications to come in, have review. 30 may be a bit restrictive. And so would we want 60 or 90 with an absent seat?
Well, first off, I think that I'm against the governor getting involved ever. I think that's his role. I mean, we're too small of a town. He wouldn't even pay attention to us in that respect. And he would probably call and say, who should I appoint? Look for somebody local that would give him advice on that. I think that a 90-day period for the commission to come up with an answer is not unreasonable. And then if they can't get it, then we'd go to a special election.
Yeah, that's how I read it and would agree, right? If we could do 90 days, I'd like to see that. Gives everybody time to wrap their heads around it. And I would be also in favor of a special election.
Are there any cons to stretching it as far as 90 days? Would that disrupt any functions at all?
So the commission can function as a 4-person commission. So I don't see, other than, maybe not having a quorum, because then if 2 people get sick, under normal circumstances with 5 commissioners, you can still have a quorum when 2 people get sick, but that's really the only circumstance that I'm seeing where it would be extremely disruptive over a period of 90 days. Now, if you're talking about a full year, you're probably going to see situations where 2 commissioners can't come sometimes. But this, I will say too, the longer the time period we have, the more time to get the word out to residents who may not be aware that there's an opening. And so you really, get your full group of interested folks, rather than having to, meet a deadline and maybe some folks weren't aware it was going on during that time.
And that's the limit. It doesn't require them to take the full 90 days if there's a qualified candidate.
Right, exactly.
And I think I just want to add that as we move forward, there is a section on quorum and voting and how to resolve those issues. I've got questions on that later, but as a 4-member commission, I think there's some guidance in the quorum and voting section as it relates to conflict or maybe a deadlock vote.
Would you all like for me to bring you back some proposed language at the next meeting on this? Because I didn't do a strike through and underline, just had kind of given some ideas of where we might go, but it sounds like folks are liking the 90 days and special election. Is that accurate?
Yeah, I'm in favor of that.
I would
Okay, I will bring back some proposed language to you at the next meeting then.
Next meeting's next week.
I will get right on it. Yes, I did know that.
acting town manager, so we will move forward to the proposed revisions to the quorum and voting section.
We didn't address paragraph 3, which is the section 2.5, filling of vacancies. But I'm fine with the changes.
Oh, you're absolutely correct, and I had a question there. And I think my inquiry is kind of maybe not fleshed out, but when we look to the filling of vacancies in a candidacy, obviously death, withdrawal, or removal. I think it's contemplating an early voting situation in section 3D1. as it relates to the qualifying, period. And so obviously, if it results in two candidates remaining, then we'll proceed with those candidates. Otherwise, null and void. So I just want a little more explanation on that provision.
Of the filling of vacancies in candidacy. Yes, so this is when there is a vacancy in the candidacy of the people who are actually running. So you're right, this one does come into play while the election is going on. If you could just give me one moment, I need to review what this
While
one
you're
says.
reviewing it, the way I read that is that the qualifying period is the date as which you have to be able to put your name on the ballot. After that date, when it's locked in, if there's still two that are available, the election goes forward. If there's less than two, that one person that's still there becomes appointed to the position without an election.
I do have a question. So they don't, maybe I'm reading it wrong now, but they don't get on the ballot and prior to the end of qualifying period? Okay. So I'm just wondering if this, just to say without the from the ballot, if the death, withdrawal, or removal of a qualified candidate following the end of the qualifying period results in at least two candidates remaining for that office, the election shall proceed. So can you double check that? Because if they were to die while they were qualifying or withdraw, then they wouldn't ever make it to the ballot, if that makes sense.
So that brings to question my inquiry with my notes said early voting. So let's say that the ballot was prepared and we had two candidates on the ballot, one in early voting. So let's say, I don't know that early voting would be in this scenario, but that's a general or whatever election and we're allowed to early vote. And they're saying that any votes for that person would be null and void if they became removed after the. I kind of didn't really understand
Are you asking specifically how it works or?
that. Right, so let's say there's a ballot and we've early voted and that person dies during that early voting period. The people who voted for that person, their votes will be null and void. It gives the instance of two candidates. But what if there were three? What would be the reaction? The three candidates.
I don't know if there's already something built into state law that I will ask Wade that question. Wade is our office's election law expert.
I'll just ask because I'm curious and I didn't commit all this to memory just yet, but if I'm understanding correctly, the way the language is written or being proposed to be changed, if there's a vacancy and only one candidate puts themselves forward, at the end of the period for accepting candidates, there is no election that one person gets that position. Is that correct? Okay. So I think that stresses the importance of notifying the public that a seat or something is available. Is there anything about that in here about making the public aware that, no, they should, I know everybody should, but I'm asking in here, is there anything that says announcement of positions or something?
That would be a from experience, I know that as soon as a vacancy appears, that's been a function of and their to post and whatever required.
Yeah. So like last time it was all posted, people just didn't pay attention, right? So, I mean, but we're as transparent as we can. And again, that is procedural. That doesn't really have to be put in the charter. But thank you.
Okay, thank you.
Of the memorandum provided language revisions would be the section 4.1C quorum and voting.
Is there a specific question about it or?
No, just open for discussion. Discussion, we would move forward with section 4.4, emergency ordinances. This was a recommended cleanup item.
I'm okay with that.
I think maybe I would, well, no, I'll retract. It was just a repetitive. No further discussion. We would move to section 5.1 regarding elections.
Yes, so the proposed amendment would get rid of the need for a runoff election. And those, as I alluded to in the memo, can be very time consuming and expensive and generally are not needed. And so this would provide that in the instance where a runoff election would have been required previously under the charter, that the candidate who has the most votes is going to win.
I would concur with that recommendation. A lot of jurisdictions have done away with runoff elections. Bill Cowles, Supervisor of Elections, was also recommending that jurisdictions do away with runoff elections if possible.
I think the idea is generally, folks came out and cast their votes and, they voted for who they want. And just because somebody didn't get 50% doesn't mean that they didn't win the election. I guess the mentality.
I think from a point of public transparency, if we could possibly obtain information with regard to the town population, the voter turnout, maybe in the last few elections, because, oftentimes residents, become alarmed when, things like that happen, but to understand the extent and nature of a runoff election, maybe providing the committee with that type of data to have in our public record as it relates to what that cost would look like. Let's say we had 20 members in the audience right now that said, we want runoffs, then we need to be able to provide the type of data that would substantiate our decision to move forward with the recommendation. If no additional comment on that particular vision, which would have been the 5.1 elections, we can move forward
The only
with,
question I would have, and it may not be in this section, what happens, where's the language that talks about if there's a tie?
In terms of elections?
Correct. Whether you have the current situation of 50%, where they both get 50%, or this new requirement where both could get 40%. What is the procedure, the process for a tie? Some places do coin flips, some people do draw straws. Do we have anything like that in our charter?
Do not see anything in our charter. So I will look into ways that that is handled for jurisdictions, and Wade may have some input on that.
Yeah, because I think that would come into play more in under the new rules, because you're going to potentially have two people, it's clear sometimes when somebody's 50% or better, that you could end up with somebody both getting 40.1%. And then what do we do at that point?
Well, I will say we would need, when we're talking about a tie, I mean, a exact mathematical, this number of votes,
Correct.
not percentages.
Correct.
Yes, because the proposed language does say that the person receiving the most votes would win. So if it's off by even one vote.
Correct. A tie is a statistical where they have statistics. It's the actual same number of votes.
I will look into some ways to handle that. Thank you.
I don't think cage matches are still in play, but
Probably not.
okay, no additional comment. Moving forward to section 6.1, procedure to amend. So I have an inquiry with regard to if conflicting amendments are adopted at the same election, the one receiving the greatest number of affirmative votes shall prevail to the extent of such conflict. And so this is my hypothetical mind saying we have two conflicting amendments, and we're going to go with the one that has the greatest number of affirmative votes. And so I think my inquiry would be, what would be the safeguard provision for revetting those conflicting amendments versus the one that received the highest? And obviously, I know that we have first, second readings of particular amendments. What would be that?
I'm sorry, I don't understand. Did you say vetting it?
And maybe I'm using the wrong language, but if we have conflicting amendments and adopted at the same election, the one receiving the greatest number of affirmative votes. And while I understand the presentation of amendments would require, first and second readings, I think I'm a little uneasy with the resolution of that language. And so I would want a little more input from your office as it relates to the procedure or the why of that provision.
So this provision is talking about once the amendments go out on the referendum and are then voted on by the public. Yes, and so our office's position is that really there should never be any scenario in which two conflicting amendments are placed on the ballot for the public to vote on. I mean, even with this provision, right, the one receiving the greatest number of affirmative votes shall prevail to the extent of such conflict. What that means is one prevails in its entirety, the conflicting amendment would remain, but the conflicting portions would be pulled out. So you kind of end up with a Frankenstein of the two. And I mean, as a legal matter, that is just plain messy.
And see how this can happen with an ordinance, because the town can put forth an ordinance. But I don't see how we could have conflicting charter, because they have to come to this committee for
Exactly, yes. And so we would suggest considering just removing this language about conflicting amendments because there really shouldn't be a circumstance in which it should apply.
I'll rescind that comment. I think it was in my mind, the commission and not.
I understood, yeah.
Oh, I think that takes us through the recommendations, right?
Yes.
One question I had from, I think last time, or it was in the minutes or the notes, and it had to do with the timing of elections. And I was wondering if we could talk about that a little bit, because I did have one little question about that.
Okay, I may need to get an answer from Wade for you, but
So there was a note in here about the financial implications of election timing. And it said, election timing, timing of elections such that align with presidential preference primaries can significantly impact costs.
yes.
Can you talk a little bit more about that?
So when we piggyback with Orange, so Orange County runs our elections in the town of Oakland, right? When we piggyback with a presidential preference primary, then they pick up almost all of the costs because they have to run a ballot, they have to run a polling place anyway. So it saves us a lot of money to be able to do that.
But we could also run it concurrently with the normal November election.
We could, our charter just doesn't say that at this time.
But that advantage would also still be there if Orange County is running elections at the same time as well.
Correct.
I just think you get better voter turnout if you do it when everybody else is doing it as far as the general election is concerned.
Yeah, no, that's where I'm going with it, right? Is if you're going to get better turnout, better participation if you align with something that's got national recognition, right? So that'd be something I would consider. Is it disruptive to do that based on how everything's worded now or no?
We would have to change all that wording in the charter. Not that we couldn't do that, but that wouldn't be in effect for like the March 2026 election, right? It'd have to be future.
And just a question about that as well. There's no early voting in the March elections, is there?
There's early voting. It's just at Orange County Supervisor of Elections. There's a few other locations locally, but not in Oakland.
So there is an opportunity. It's just the one for the general elections longer, has more opportunities both. Those are at the library as well, right?
Yes, that's correct.
Charter language revisions for clarification provided by. Public comment section. Members of the public present would.
All right, so I had a few thoughts for the next meeting. There were two items that stood out in my mind from the last meeting as being things that you all were at least interested in discussing further. Those two being term limits and districting. So few thoughts that I have. If we want to look at districting, I would advise trying to schedule some meetings where somebody from the supervisor of elections office or perhaps the supervisor of elections can come and explain a little bit about what the districting process would look like as a practical matter. I also was thinking that it would probably be helpful if you guys are interested in looking at both of those. I can sort of do a little survey and look at similar sized municipalities around Florida and see, do they have term limits and do they have districting? Because in our office's view, the feasibility of both of those things is sort of tied to the size of the municipality. How many folks are going to be running for office and how many voters are there and where do they live?
And I think, in my review of the charter, I think there's this erroneous belief that we don't have term limits because it says that we're elected for 4-year terms, which means that at the end of 4 years, there would be an electoral process opened up for residents to, announce their candidacy or intent to vie for a particular office. And so in my reading, and clarify if I'm wrong, we do have 4-year terms for the office.
Absolutely, yes. I think when other folks are talking about term limits, they mean, maximum of 2 terms or something like that. So you have a sort of an aging out of your elected officials. You're absolutely correct that there are terms.
And so I think it would be advantageous to have some just data and comparison with towns that have term maxes. I'd say maxes, not limits, but just to understand what another municipality of our size, demographic, and voting percentages would look like.
Sure, I'll bring you that data.
So I was thinking about this since last time with the districting and bouncing some stuff back and forth. And I don't know if you want to discuss it here now, but what problem are we trying to solve if we do recommend districts?
Yeah, that's a good, my issue, and I have been very active at the meetings for a while now. And I don't feel like any of the commissioners have an obligation to represent me and the issues in my neighborhood, my dirt roads and et cetera. And that became very clear to me when the vacant seat for the commission came about. And my gut feeling, purely just a gut feeling, is that if I had one commission member that was in charge of my district, that I could hold that person accountable for how I feel and what I'd like to see done, for me. I think that would work better than the current method that we have.
No, that's fair. And that was kind of like where I was going is ultimately like if we feel or if the community at large feels that you're a member of the community and feels that the commission does not represent it, then do districts solve that?
It's a great question. I've done a little preliminary stuff on this because I am interested in it. And out of the ones that he gave us, there were only 2 that did address it. We addressed it in districting, three commissioners. They have a non-voting mayor, veto, and they have 7 commissioners, even though the town is only about 1,000 people more than we are. Population's about 7,000, but they have 8 on the commission. They have 3-year terms. They have They have 7 districts. Believe that. So anyway, I think there are a lot of different ways. to look at it, so be
So in response to me, I think, you obviously, advised that you would look into other districts, and what that looks like. Give me an idea of what that response, what your thought process is as to the information that you.
I will most likely provide, not sure if it would be as simple as a chart, but right now in my mind, it looks like a chart listing jurisdictions, their populations, and whether they have term limits and whether they have a districting. And as I say that, I'm thinking, well, I'd probably want to provide some additional information in case there's anything interesting. Like Belle Isle would be a good example, where things are a little bit different there. So may not exactly be, an Excel spreadsheet looking document, but that would be the general idea, so that you can get a good idea of how comparable is this place really to Oakland, and how do they look at this issue.
And I would just, as an aside, I know we talked earlier about, voter turnout, and those statistics. I think that would be essential. Analyzing the other districts based on what our voter turnout percentages.
I will do my best to get those numbers for you. I may not be able to before the next meeting, but I'll do my best.
Yeah, I just think that we're too small of a town to have districts and restricted it. We don't get people to run to begin with. The seat that you talked about could have been easily filled if somebody had put their name in. Nobody put their name in behind it.
Yeah, I disagree with that.
Okay, that's fine. But can I finish? Yeah. So when I look at District, 1 of Orange County, where there's over 100,000 people, that commissioner represents me just as much as one of the local commissioners here. And in the town of 4,000, I don't think I need to narrow it down to just me and another 1,000 other people. So I think that we're going to create, again, problems for ourselves if we don't have people that will step up in those districts, especially if we term limit it. I mean, what do you do in that situation? Your accountability is you have a vote for all 5 of them. And your vote is just as valid, whether it's to a district or to an individual that's representing the whole town.
Because there are no term limits, let's say that nothing's going on in the town. Everything's just kind of percolating along fine. Everybody's having a good time. So if there are no openings in the town, I think a lot of people will just say, the commissioner is a nice guy. Why would I want to run against him? I mean, things are going fine right now. But if there's a vacancy, then I think there are going to be people, I think I'm interested, and I think I might run. And that certainly was the case, previously. So I understand your points, but I just think that there's a dynamic that we've missed, because I've heard that argument from the other commissioners too. It's like, how many unopposed races have there been? Well, that's because you put your name on it. Nobody wanted to run against you. I think that's one dynamic, is that not that we're necessarily unhappy with that commissioner, but just that there's not an opportunity, an easy opportunity for someone else to get.
Well, I think you're referring to the power of incumbency. And in this case, our incumbency is they're filling a role and they're not getting paid. If they get paid, it's nominal. And I'll just go back to the last election. Exactly the case you're describing was there. It was wide open for anybody to run for, and nobody did.
Can I,
What are you referring to, Kurt?
When Sal put his name in for mayor, his seat was vacant. Nobody filled it. If one person had put their name on that ballot, they would have been the commissioner. We would never have had gone to.
It wasn't an election.
Yes, it was. Absolutely was.
For Sal's seat? No, it was an appointed seat.
There was an
There were
election.
11 people that signed up.
There was an election before that seat became vacant and filled in the way that you're thinking.
So
When Commissioner Ramos ran for mayor, his seat. There was no one running to take his seat. And so we ended up with a vacancy on the commission because no one put their name in the ring.
I'll speak to it personally because obviously I put my name in the appointment process. I was very well aware of Sal's vacancy. I looked at putting my name in the hat to run for the position as maybe premature for my thought process or, running an election. But the opportunity absolutely existed in December of that year to put your name in the hat to run for that seat. At the termination of the period, when no one did that, then that opened up the appointment process. And so, as we talk about the rumblings of, what happens, we're disgruntled, but we're not always apprised of the process. And so in hindsight, I likely should have put my name in the hat and just, leaned on my neighbors and friends to support me in the election and not worry about the cost of an election or the expense of, running a campaign, because actually I probably would not have had to do any of that because it would have allowed me to assume the seat because it would have been an unopposed. And so I think that I want to speak to your point in that, because when we talk about elections and term of office, there's also staggering. When we talk about, term limits, there are 4-year terms that at the end of those terms, it is open for any member of our community to run for a particular seat. And section 2.3 speaks to 2 and 3 will be elected in the presidential year and 1 and 4 in a gubernatorial election year. And so as a community as a whole, when we think about the fact that there are no term limits, there are terms of office. And at the end of each term of office, there's an opportunity for each member of our community to put their names in. And I understand your point. Well, if we believe that Commissioner Ramos is doing great, why would I oppose him? Then why would you come and sit in a meeting and discuss or be disgruntled about the fact that the 5 members have been sitting here? So I think that's just a community effort that we'd have to work at another.
I just want to make 2 really quick points because people aren't always aware of these 2 things. Is if somebody that's an incumbent wants to rerun, they have to requalify, right? Every time they have to put their name through, they have to go through the entire process. It's not like a given. Number 2 is during that qualified period, we're not announcing who's running, like who's qualified. We only do that at the end of the qualifying period. So nobody technically should know who's running against whom until the end of that qualifying period. Does that make sense? So really nobody should know like so-and-so's running unless they're acknowledging it themselves.
Stephanie, I guess a question, if I think about what I'm hearing is representation for the different parts of the town, which, we want to say districting might fix it. So I'm interested in your firm's ability to comment on, is there another way to represent maybe underrepresented participants of the community? So that's one question. The other question I can't help think about that goes hand in hand, and I don't know where to get more info on this, but is there anything we could do as a town, and maybe it's out of the scope of the charter review, but increase that civil service mindset? Is there anything we could do with, I don't know, youth groups, something where things are aging out, right? We mean, it's a very common group of people that sit up here, and I appreciate what they do. But as I look forward and I go, okay, well, one of them is going to retire at the next cycle. No one wants to step up. What are we doing now to help promote that? And I don't believe it's something that goes in the charter, but I'm just kind of curious. Those are the 2 points. One, what tools do we have? And 2, can we look further out?
Or, I think your instinct is correct that while there is a lot that can be done in that regard, the charter may not be the place where we want to do it. The first thing that comes to my mind is potentially some sort of, board with the power to make recommendations. And this is, I'm completely just brainstorming on the spot here. But if it was the commission's desire, they could certainly create a board with representatives from all around town who, maybe folks can come and make recommendations that, hey, we feel this this area of town has this issue going on, and maybe you all are not aware of it. And so we'd like to make a recommendation that this be looked at. Certainly, there are lots of municipalities around Florida that have those types of boards. And I think the commission is a fan of the Boy Scouts. They come and make presentations sometimes. So there is some community outreach and involvement already going on.
Any further comments? The stated remarks? Okay. Her personal privilege as the chair, I want to commend Elise for her ascension to town manager. Well deserved, and we appreciate all the work that you have done in your prior capacity and look forward to all the things that you're going to do as a town manager. We will move towards our next meeting, which is April 7th at 3 p.m. I do want to,
Sorry, excuse me, sorry. I didn't realize you were moving forward, but so discussion items for next meeting, are we closed with that? or no?
I think,
I had some recommendations.
oh,
So I will be coming with, as I said earlier, some proposed language based upon our discussions today and some data information about term limits and districting. I also would recommend that each of you take a look at chapters 1 through 3 of the charter. It sounded like there was somewhat of a consensus at the last meeting that we sort of just take chapters in order and move through that way. So I think given the good start that we've already gotten, we could probably do 3 chapters at the next meeting. And that will be just, you can all sort of write down items of discussion or proposed amendments, and we'll just take it piece by piece.
So I think last time we met, there were some comments too, and they were in the notes. So I don't know, was a backlog started or like a FAQ? I think that's what I understood last time, that there would be the items that we're discussing in the next meeting, then a list of items that were not going to be discussed at the next meeting, but are kind of put up on the board for future discussion. Has that been put together? Or can that be?
I think I had a list that were in the minutes on next steps. I think that was a
That's it.
pretty comprehensive
Yeah.
list. If you
Okay,
wanna
so that's the
look
one.
at that and
Yep.
kind of pick out things that you think might come next. As Stephanie said, if we're looking at chapters 1 through 3, we may be covering some of these things. But if there's something else that you think should move as a priority, we can definitely think of that at the next meeting.
Yes, that's a better question, I guess, is how does that list next steps align with the 1, 2, and 3? Or does it not?
so I think that based on Stephanie's calculation of what she would be providing at the next meeting, would the items would have been the term limits, the districting, and any supporting data that she's able to provide in that short time frame. And so those would be her action items produced at the next meeting. And so in addition to that, since there was some interest in addressing each of the articles of the charter, she recommended that we review items 1 through 3, and then we could provide some commentary or feedback on items within those articles that we would like to have reviewed.
All right, thanks.
Any additional discussion?
Not from me.
I think the only other personal comment that I may have had about the charter review committee process is that I don't know, and I could be just not in tune with the announcements, but I don't know that I saw many announcements about this meeting occurring via our portal. And so obviously the absence of the public here in a physical capacity, I'm not sure who's viewing online. Just want to make sure that we're providing adequate notice of these meetings to allow for the public to either be present or provide commentary to the town manager.
We'll try to do a better job getting it on our Facebook page. It is on our website. It has its own news alert. And it's on the calendar on the website, but we'll try to do a better job reminding people on Facebook.
Awesome, thank you. If there are no additional comments or requests, we would move to adjourn the meeting at 4:16 PM on March 31st. Meeting adjourned.
Thanks.